Hello, welcome back to Law Simple. I went to law school so you don't have to, and today we're going to be discussing statutory interpretation. What do we do when Congress passes a law that has vague language? Congress, of course, refers to the 535 men and women who write legislation that governs the entire country. Whatever you might think of them, this body's greatest flaw is that it is made up of humans. And humans often make grammar mistakes, overlook important issues, and just generally cannot foresee every single possible edge case that might arise. Now, in a much smaller, less complicated world, this might not be an issue. However, there are over 130 million people in the US. All those people are living, working, getting into arguments, and looking to the government for solutions to their highly specific problems. For most people, the laws as written work fine, but with 130 million people, eventually an edge case will pop up that Congress didn't consider. Congress cannot just amend the law every single time this happens, but someone does have to decide where the line is when a gray area is found. These gray areas and edge cases are where lawyers live, and figuring out what to do is called statutory interpretation. But how does statutory interpretation work? How do we decide what to do when the law is unclear? Well, that's the topic of this video. To illustrate statutory interpretation, I think it's best that we look deeply into one case as an example. The case that I've chosen was decided by the Supreme Court earlier this year and is called Stanley v. City of Sanford. Briefly, here's what's going on in the case. The city of Sanford is a small town in Florida located about an hour's drive north of Disney World. Stanley is Lieutenant Karen Stanley, who worked for the city of Sanford as a firefighter starting in 1999. And the controversy in this case revolves around the retirement plan available to retired firefighters. At the time that Lieutenant Stanley was hired, the city's retirement plan included health insurance until the age of 65. In order to qualify, a person had to work for the city for at least 25 years. However, there was an exception for those who were forced to retire early due to disability. These retirees would receive health insurance until the age of 65 as if they had worked the full 25 years, even though they technically didn't. However, in 2003, the city quietly changed its policy so that quote-unquote regular retirees would receive health insurance until 65, but disability retirees would only receive health insurance for 24 months after retirement before being kicked off the plan. Now, fast forward to 2016 when Lieutenant Stanley developed Parkinson's disease, which was likely caused by excessive smoke inhalation during her role as a firefighter. She continued to work for 2 years after her diagnosis, but in 2018, Lieutenant Stanley's Parkinson's had progressed to the point that she was forced to retire prematurely after 19 years of service. It was at this point that Lieutenant Stanley realized that she and other disabled retirees were being treated differently by the city's retirement plan. Lieutenant Stanley then sued the city, alleging discriminatory treatment under multiple state and federal statutes, including the Americans with Disabilities Act, also known as the ADA. Now, that's it for the basic facts. But there's one last bit of important procedural context that we need to talk about. Lieutenant Stanley's case came to the Supreme Court on a motion to dismiss. Now, I might one day make a full video on civil procedure basics, but for right now, here's a quick and dirty crash course on how motions to dismiss work. Don't worry if it doesn't fully make sense, it's not crucial for this video that you understand it. Basically, think of filing a lawsuit as getting on a highway. Just because you got on the highway doesn't mean you have to follow it all the way to the end. There are lots of exit ramps that you could take along the way. Similarly, just because someone filed a lawsuit does not mean that the parties have to go to trial. In fact, they rarely do. And the very first exit ramp on the lawsuit highway is called a motion to dismiss. There are lots of reasons a defendant might be able to file a motion to dismiss, but the most common is a motion to dismiss under Rule 12b-6, failure to state a claim upon which relief can be granted. Basically, when the defendant files a 12b-6 motion, they're saying, the thing I am accused of doing is not illegal. Now, this is very different from saying I am not guilty. Imagine you saw me walking to my car in the parking lot. You get excited and wave at me, but I roll my eyes and don't wave back. You are rightfully deeply offended and so file a lawsuit against me. I could respond with a motion to dismiss that says, look, even if we assume everything you're saying is true, Not waving back isn't against the law. I'm not saying, actually, I did wave back. I'm saying whether or not I waved back doesn't matter. It is at this stage that Lieutenant Stanley's case came to the Supreme Court. She has not had a chance to gather evidence. She has not had the chance to prove the discrimination occurred, and she has certainly not presented her case to a jury. The Supreme Court is not ruling on whether Lieutenant Stanley was discriminated against, but rather on the much more fundamental question, does Lieutenant Stanley get to sue at all? Do the ADA's protections even extend to retirees, or do the protections against discrimination end once you take retirement? To answer this question, the court focused on Section 12.111.8 of the ADA, which is the section that lays out what the ADA does. This section says that the ADA makes it illegal for employers to discriminate against a qualified individual on the basis of disability in regard to compensation. The statute then defines qualified individual as an individual who, with or without reasonable accommodation, can perform the essential functions of the employment position that such individual holds or desires. Here's the issue, though. The ADA says you can't discriminate against a qualified individual, but it fails to specify when a person has to be a qualified individual. Lieutenant Stanley was a qualified individual at the time she accrued her benefits, but she was no longer a qualified individual when the alleged discrimination occurred. Does a person lose their qualified individual status when they retire, or is it a once a qualified individual, always a qualified individual situation? Well, I'm going to go ahead and spoil it for you. The Supreme Court, in their infinite wisdom, decided to side with the city of Sanford, holding that the ADA's protections end at retirement. That in itself is extremely important information to have, especially if you or anyone you know is retired or approaching retirement. But the more interesting question is, how did the Supreme Court arrive at this conclusion? Well, to wildly oversimplify, you can think of statutory interpretation as having two basic camps. On the one hand, there are those who believe we should be looking at the text of the statute and nothing else. I'm going to call this group the textualists. On the other hand, there are those that believe we should be looking at the statute in context to try to figure out what Congress intended for the statute to do, and then interpret vague parts of the statute in a way that aligns with that intention. I'm going to call this group the intentionalists. The textualist approach was the approach used by the majority in this case, so we'll start there. In order to determine when the ADA's protections end, the majority started by looking at the verb tense used by Congress in the statute. The majority noted that Congress had used words like discriminate, can perform, holds, and desires. The majority determined that use of present tense verbs hinted that the statute protects individuals who are able to do the job they hold or seek at the time they suffer discrimination. You'll notice that this argument relies heavily on the grammar and the words of the statute itself. Pure textualists believe that a statute's meaning must be found within the text. No outside information or evidence should be taken into account. If you're ever reading a judicial decision for whatever reason, and they start making grammatical arguments or referencing a dictionary, they're making a textual argument. The majority continued their textualist approach and noted that elsewhere in the statute, the ADA lists some potential accommodations employers could provide disabled employees, and that list includes job restructuring, modifying existing facilities used by employees, and altering training materials or policies. These accommodations, the majority noted, are all things that only really apply to someone who currently has a job, hinting again that the statute should not be interpreted to cover someone who previously had a job. The final example that I'll pull out of the majority opinion is where they compare the language at issue with other language in the statute. Elsewhere in the statute, the ADA makes it illegal for an employer to punish someone for opposing a discriminatory act. However, in this section, instead of using the term qualified individuals, Congress made it illegal to retaliate against any individual. The majority argued that when a document uses a term in one place and a materially different term in another, the presumption is that the different term denotes a different idea. Here, the majority is saying we're going to assume Congress did not use these phrases by accident. If Congress had wanted the same group covered in both sections, they would have used the same language, and so the term qualified individuals must refer to a much narrower group than the term any individual. Basically, the opinion boils down to if Congress wanted the ADA to extend into the post-employment period, Congress could have written the statute differently to make that mandate clearer. We have to take the words and only the words into consideration, the majority says. While the words aren't immediately clear, they suggest that a person must presently be a qualified individual at the time of discrimination. This means that Lieutenant Stanley, being a retiree that does not hold or desire a job, does not get to sue, even if she was discriminated against, as she alleges. But of course, that's not the only way to interpret a statute. As I mentioned earlier, other people argue vague statutes should be interpreted by considering context to determine what Congress likely would have wanted the outcome to be. This intentionalist approach is the approach used by the dissenting opinion. To resolve the ambiguity present in the statute, the dissent argues that we need to attempt to understand the context in which the qualified individual definition appears in the ADA, as well as the point of that provision, i.e., what exactly Congress designed that definition to do. In other words, looking at the text alone is not going to give us the answer that we need. We need to understand the intent of Congress as well. The dissent begins their analysis of the statute with the statute's codified purpose. In Section 12101B, Congress specifically states that the ADA was intended to be a comprehensive national mandate for the elimination of discrimination against individuals with disabilities, and to provide clear, strong, consistent, enforceable standards addressing discrimination against individuals with disabilities. Where the majority would have us analyze the term qualified individual through its use in the statute, the dissent would have us look at congressional records. Citing the official congressional record, the dissent notes that Congress incorporated the qualified individual provision into Title I of the ADA to address a particular problem. By adding this provision, Congress simply intended to reaffirm that the ADA does not undermine an employer's ability to choose and maintain qualified workers. For example, a jewelry store can still require a security guard to be capable of mobility and dexterity, and a contractor can still require a construction worker to be capable of lifting heavy materials. Including the word qualified was only there to recognize that in certain situations, employers may lawfully discriminate against applicants based on disability if disability renders someone unable to perform the essential functions of a job. The record makes it clear that this word was not meant to serve as a temporal limit that extinguishes the rights of those who already did the work and have now left the job, nor would this make any sense, given the expansive goals and broad mandate that Congress codified for the legislation. The dissent's basic argument, therefore, is this. The words of the statute might be read to exclude Lieutenant Stanley from ADA coverage, but much more important than the rigid grammatical construction of the statute is Congress's intent. The record and the statute's codified purpose shows that Congress would have wanted Lieutenant Stanley to be covered, but they just didn't realize at the time that their word choice might exclude her. Congress is made up of humans after all, and humans miss things. When dealing with vague language, we should interpret it in a way that aligns with what Congress probably meant, rather than what they literally said. To be clear, there are criticisms of both approaches. Textualists argue the codified purpose shouldn't be given that much weight because legislation never pursues its stated purpose at all costs. There are 535 members of Congress after all. Passing legislation requires compromise, and language that is narrower than the stated purpose might very well be a compromise. Intentionalists criticize this approach and argue that compromises do not make the legislative purpose irrelevant. If a statute's text is unclear, they say, it is not the court's job to twist and turn the words until they make sense. Viewing a statute in light of its aims allows the court to carry out Congress's likely intent. But intentionalism is also criticized as being too pliable, and that it allows judges to bend the record until they get the result they seek. But intentionalists, I think, validly point out that looking at the words alone isn't as free of bias as one might intuitively think. They argue that textualists' refusal to understand the statute allows judges to find answers they prefer without bothering to consider whether those answers align with congressional intent. And in that way, these unelected judges take over the role of legislator. To be perfectly honest, I lean heavily to the side of intentionalism. When making decisions that affect the entire country, I don't see how including more sources of information could ever be a bad thing. However, what I find most interesting about this debate is that both sides are really trying to do the same thing: figure out what the heck Congress meant while inserting as little judicial bias as possible. The philosophies really only disagree on what tools are best for achieving this goal, something that is frankly impossible to ever know for sure. Thank you very much for watching. If you learned something and enjoyed this kind of video, please consider subscribing. I will be posting videos like this once a week, and if you got time, I'd love to hear your thoughts. What do you think about a statutory interpretation? As I said in the video, I personally lean toward intentionalism, but do you agree? Do you maybe lean toward textualism? Or do you have a completely different approach? I'd love to hear what you would have done if you were a judge in this case. Leave your thoughts below in the comments, along with any other legal topics you'd like a future video to cover, and I'll do my best to respond to you. Thanks again for watching, and I'll see you next week.